the inductions of the new members. The last panel is Zombie Apocalypse, Preparing for the End of Suspension of Director's Duties to File, with Christian Hilpert, Dhananjay Kumar, Kathlene Burke, and Paulina Fishman. I'll turn it over to you, and their very interesting backgrounds.
Well, hi everyone, and thank you, Evan, for the introduction and for III for the opportunity to speak to you all today. I want to welcome all the new NextGen members and the new III members and apologize that we can't be there in person. We're here to have a conversation about zombie companies, something we've been hearing about at the conference, and what effect emergency COVID-19 measures have had on different economies in each of our jurisdictions. The comparison here is quite interesting because each jurisdiction is in a different stage of economic recovery. And after our discussion, we'll have some time for Q&A. But if you have questions during our chat, please put it in the chat and we will try to answer them as we go along. It's going to be a conversational type talk, so hopefully you enjoy it. And we're just going to get started. Our different jurisdictions are in order of chronological lifting measures: Australia, India, Germany, and the UK. So we all know that parts of Australia are currently in lockdown and will emerge. Some of them will emerge soon, some of them, who knows. But ironically, Australia was actually the first in our group to begin lifting measures. So let's start there. Paulina, tell us a little bit about the temporary measures in Australia and what's going on there.
Yeah, absolutely. Thank you, Kathleen. So I am in Melbourne at the moment. In Australia, we are currently in lockdown, as Kathleen mentioned, hoping to emerge soon, very soon. But it's been very tricky for businesses in Australia with coronavirus. The first thing I just want to mention is that in Australia, instead of having a duty to file, what directors have as an obligation is a duty to prevent insolvent trading. And the relevant provision is 588G of our Corporations Act. So it's a little bit different from a duty to file. But nonetheless, the idea is that if your company is already insolvent and you're a director, you have the obligation to prevent it from incurring a debt or debts. You also have an obligation to prevent it from incurring a debt or debts if that would make it insolvent. So that's sort of the idea behind the duty, that you stop your company from insolvently trading. And it's typically a civil penalty provision. However, if you suspected insolvency and acted dishonestly, then it's actually a criminal offense as well. And the maximum penalty for that is as much as 5 years imprisonment and potentially a financial penalty as well. So this is the obligation that we sort of commence with when we're looking at what directors have to prevent. But previously, prior to the outbreak of the pandemic, we already had, for instance, defenses to this, things such as if the director was ill and therefore not involved in management, or took reasonable steps to prevent the corporation from incurring the debt. And the section for that is 588H. And we also had a pre-existing safe harbor, so pre-pandemic safe harbor. And that was if the director developed a course of action that was likely to, reasonably likely to result in a better outcome for the company. And the debt was incurred in connection with that course of action that was developed. And the relevant section was 588GA. So this was sort of the context to sort of paint the picture. And then the outbreak of COVID. And so the temporary measure that was put in place in Australia was an additional but temporary safe harbor. So this safe harbor provision, the relevant section was 588G AAA, So that was if the debt is incurred in the ordinary course of business during the relevant period. And the relevant period for us was from 25 March last year to 31st December last year. So as Kathlene mentioned, we're of the 4 jurisdictions represented on this panel, we were the first ones to wind back this temporary provision that applied because of the coronavirus. And so all of this year, we have not had that provision apply. So we've had, quite a number of months now without it. But in addition, there were other temporary measures put in place. So one that jumps to mind is in order to serve a company with a statutory demand with a view to wind up the company eventually. Previously, your debt had to be at least $2,000. So as a temporary measure, this was raised to $20,000, right? The sort of related change that was made is that previously, the company that's been served with a statutory demand had 21 days to reply or respond. And this was extended to 6 months. So again, this is sort of the package of measures put in place to try to assist businesses. And in terms of that, the greater statutory minimum and the greater statutory period, that was applicable to all companies in Australia from 25 March last year until 31st December last year. So the same as the temporary safe harbor. However, there's been a sort of extended application of this for certain eligible companies, and that was until 31st July of this year. So certain eligible companies, they still, to have the statutory demand, you still had to have a minimum of 20,000, and they had the 6 months to respond. And the final thing that I'll just mention, which is sort of temporary, but also ongoing and ever changing, and that's the financial support from government. So we, for instance, had a wage subsidy initiative in Australia called JobKeeper. So JobKeeper payments were made, and this was from 30 March last year until 28 March of this year. But just because that particular initiative has been phased out, there are still other programs in place. As I mentioned at the beginning, I'm in Melbourne, we're still in lockdown, and businesses that are affected by lockdown in particular are still receiving financial support under different programs here. So that's the situation in Australia. I'm interested in what's happening in India. Dhananjay?
Thanks, Paulina. Hi, everyone. Thank you for listening to this panel. I'm going to talk a bit about what measures were put in India and what's happening once the measures have starting to phase out. In terms of pure insolvency measures, we had the minimum amount that is required to put a company into insolvency. Before COVID, it was 100,000 rupees. And post-COVID, it has been increased to 10 million rupees. And that's effectively a permanent measure that has been taken, that has not been phased out. The second, which is a very interesting, and probably we have not seen it elsewhere in any other jurisdiction, is that the Indian government said that if there is a payment default, just to highlight that point, that in India, the trigger to put a company into insolvency is a payment default and not an inability to pay. It's a payment. If that default occurs, only then you can put a company into insolvency. What the government did as part of COVID measures is that they said that if there is a default which occurs after March 25th, 2020, and they picked a window of 12 months, and they said, first we will start it for 6 months. So if there is a default between March 25th, 2020 to September of 2020, no insolvency can be initiated against such companies. Ultimately, those were extended till March 24th of 21 because there was a 12-month window. So that was a COVID measure that was put in place, but that has now been phased out. However, interestingly, the law also says that in respect of such defaults which occurred during this period, an insolvency petition can never be filed. That's a very interesting feature of the changes that were put in place. And very similar to what Paulina was talking about, Australia, we don't have a duty on the directors to file, but we do have a duty on the directors to prevent insolvent or wrongful trading of the company when they have no prospect of avoiding a payment default. The third measure that I would speak of is similar to what Paulina was speaking about insolvent trading. And what the Indian government did was, they said that, I spoke about this period of March 25th to March 24th. We do have a wrongful trading clause, which is very similar to the English insolvency wrongful trading provision. And what the COVID legislation suggested is that no director can be liable under that provision, which is section 66 of our insolvency code, for any default that takes place in that specified period. And we have not tested, and I guess this is a question common across many jurisdictions, that what happens to sort of look back period for avoidance transactions, what happens to a transaction that took place, but that's something that remains untested. There are other measures. These are sort of the pure insolvency measures. Of course, there is government line of funding, which has now been extended up to March 31st of 22. And that continues to remain available. There were ad hoc restructuring schemes proposed by our central bank, where the banks and the shadow banking industry could take benefit of. But there were not so many takers for that, given the uncertainty in the market and the economy in general. And therefore, what we have just now is more companies looking to obtain funding under the emergency credit line that is available till March 21st. So that's about India. As I said, the primary phasing out that has happened is in respect of the specified period during which the default cannot be subjected to an insolvency petition. But I guess Germany would be the next in terms of the order that Kat suggested. So I'll turn it over to Christian. Christian, your thoughts on this?
Yeah, thank you, DJ, and a warm welcome also from me. Thanks for having us here today. So yes, Germany, you're absolutely right. Germany would be the next. So we lifted the suspended duties at the beginning of May this year. But to start with, I think the main difference is that we have a duty to file. So there is a director's duty in Germany, opposite than the other jurisdictions we've now seen or heard of, to file when you are either illiquid, meaning you can't pay 10% or more of your debt when they fall due, or over indebted without a so-called continuation prognosis, which means that the company cannot technically survive and recover within the next 24 months. So that would be the German standard proceeding bottom line. One part of the measures the government took in the insolvency law was simply suspending these duties. So there was no need for the directors, and the effect was pretty obvious. The directors didn't go, and only a very, very small number of insolvencies happened during the COVID period, because the non-compliance with the duty is actually punished quite hard. It can be a criminal issue, it can be a civil liability issue for the director. So there is a high pressure on that. But that was a very technical piece. So suspending the duties, thereby not increasing the numbers of filing, was only part of the answer the German government gave. And it's only part of the answer to the zombie problem, which has been created partially by the pandemic in Germany. So the next one is that, again, on the insolvency side, in addition to the suspension, they tried to incentivize shareholders by privileging shareholder loans that were given during the pandemic. So avoidance rights to challenge transactions, all that stuff has been is still not applicable to shareholder loans given, thereby trying to trigger obviously shareholder finance to get into the businesses. But the vast majority actually happened outside by governmental loan schemes, by governmental securities provided via commercial banks, and especially on the employee side. And that piece is actually still going on. There are discussions if that's going to be extended even into 2022. But there is a program which we called short-term labor, where you can get governmental funding or it's a subsidy basically. If you do not terminate the contracts, do not wind down the business, and at the same time you cannot sufficiently provide for work for the people. So you send them home and you get a significant portion of the salaries. And obviously for most businesses, at least in Germany, which is a high cost country, wages and salaries are one, if not the main factor. So by doing this, companies could, in addition, build up cash during the pandemic. So you had a situation where you could benefit. You didn't have your major cost blocks. At the same time, you were able to get access through governmental funding, loans, schemes, whatever was available, and partially still is. Plus, you had some privileges to obtain shareholder funding. So it was a pretty strong situation where actually all sort of business models, be the defunct business models or whatever, could ultimately get access to funding and could save costs during the pandemic, which most of them did. So as a result, numbers went down, they have when that was lifted 1st of May, there was obviously the concern that might immediately give rise to the new filings and that they will simply go up, but that hasn't happened at that point. It's actually a very interesting thing we will touch on later when we look a bit more into the zombies. But Kat, how about the UK being the last in the row?
Last but not least.
Correct.
So unlike Germany, in England, there's no absolute obligation to file an insolvency petition. There is, however, a duty for directors to act in the best interest of the company, and the duty changes with decreasing solvency, sometimes referred to as the zone of insolvency. And the duty will shift from shareholders to creditors when you get closer to the zone. Amongst other obligations, and similar to India and Australia, there is a statutory liability that could arise for wrongful trading during the zone of insolvency. So on March 28th, 2020, shortly after the first lockdown was announced in England, the UK government announced that it would be suspending the rules on wrongful trading. And it expedited changes to insolvency reform that had been announced back in 2018. So along with the temporary suspension of wrongful trading, the government implemented a host of COVID-19 measures similar to every jurisdiction. And they temporarily suspended various filings and various requirements. They introduced a moratorium for distressed companies that you could invoke and a new restructuring plan that you've all been hearing about, maybe ad nauseum. So this was all done through CIGA, the Corporate Insolvency and Governance Act of 2020. And although it was passed in June, the temporary measures were retroactive back to March. The restrictions on winding up were, I think, interesting because it was very similar to India, where you couldn't present a winding up petition during the relevant period unless there were reasonable grounds to believe that coronavirus hadn't been the reason for the defaults and had made the company unable to pay its debts. Initially, temporary measures were due to expire in September of 2020, but as you all know, England has struggled with coronavirus since the get-go, and we are still somewhat struggling with it. So the measures were extended again and again. At this time, though, they have all expired as of the end of last month. And that leads us to the impact. So what have you been seeing in your various jurisdictions upon lifting of measures? I know Christian touched on this a little bit. Has there been an increase that's led to zombie companies? In England, it's a bit too soon to tell. I'll go first since I went last before. The measures have just been lifted, so we don't really have the full picture. And on top of that, there's a lot of money that's been pumped into the system. So as the case with other jurisdictions, The government provided financial relief in the form of grants, loans, tax relief, suspension of requirement to pay certain debts. There was a financial aid package of $4.6 billion to support businesses and protect jobs in connection with the most recent lockdown. There was a business in the retail, hospitality and leisure sectors grant worth $9,000 per property to help businesses through the spring. There was a $1.1 billion discretionary grant for local authorities worth up to $3,000 a month throughout the furlough scheme. There's just been an incredible amount of money pumped in. The last package that the government spent roughly $300 billion on supporting the economy through COVID-19 restrictions. And that's not surprising considering we've been in lockdown for a long period. Unsurprisingly, as with Germany and most other jurisdictions, the measures that have been put in place worked. And as you've heard in the talk that Ed Altman did, there hasn't been a lot of insolvency filings. In particular in England, there's been a huge drop with the introduction of measures. I think we're down 22% lower than in the last quarter of 2020 and 38% lower than the first quarter of 2020. So I'm going to go and turn it over to Christian because I understand there's also a similar case going on in Germany.
Yeah, it's actually very right, Kat. The situation is similar. So Germany as well as China have both been hit hard, and I got hold of a study from A.T. Kearney today showing that, funnily, the zombification in these two countries has tremendously increased since the last financial crisis. The number of zombies, according to the A.T. Kearney study, has tripled, and 2022 adding 13% on that. And that's in particular for Germany and for China. And there is an interesting question on why that's the case. The one answer is that these countries have been hit hard, but it's also about the structure of the businesses. That's where you will find the zombies in Germany. So there's a lot of small and medium enterprises in Germany, especially sitting in production, engineering production, automotive industry, and similar industries. And especially these types of businesses are in a transition. So the zombification we are seeing here in Germany is not the result of the pandemic. The pandemic is a result or a catalyst or a speed boat to the whole problem behind it. And the problem behind it is that these are normally industries in transformation, small and medium-sized enterprises who are lacking investments for quite a bit of time, who have a defunct / non-transformable business model, and thereby had certain difficulties despite the liquidity that was available in the market to finance their businesses and to turn them around into more profitable working future business models. And with the situation of COVID, that has changed a bit, because even these defunct business models could easily get access to financial support by making use of the schemes, by making use of the governmental supports. And so, the finance side basically has not asked, does your business model work? And that has actually especially been for the benefit of these small and medium-sized enterprises in these transforming industries. The result is that we are seeing a cocktail in certain types of industries. Automotive is a big thing, so supply chain within automotive is a big thing. Retail is an obvious one as well, but also real estate to a certain extent, where companies as a result of that are getting zombified and are actually lacking resilience. And with that lack of resilience, you just need a very tiny little minor trigger event to get the whole thing going. And that's what we are starting to see here at the moment within the automotive industry. Because of the chip shortage, which is a trigger event for the manufacturers, reducing their call-offs, and that actually hits them in that situation. And it's difficult to predict where that sits. I think the takeaways we are having here at the moment is size matters. So small and medium-sized companies are hit hard, whereas the larger multinational corporates, the digital business models aren't so much. And the next one is you need to have a cocktail to make this work. So if the pandemic was your only concern, you'll probably not get zombified, at least from a German perspective. Whereas if you are in a process of transformation, which you haven't managed properly, and then the whole thing comes on top, that's where the zombification starts and where things actually start to move quite quickly. And that's actually an unpredictable situation at the moment. We haven't seen the filings going up. In May, we are now seeing it in certain industries that things are happening. They're happening very, very quickly. But it's clearly not going to be a tsunami, at least in Germany. DJ, I understand that India has done something quite unique in that there are ongoing defaults that can never be called. Can you talk a bit more about that and whether the lifting of the temporary measures has contributed to the zombie companies in the system?
Sure, Christian. So as I was mentioning in my opening remark, the law that came in, the amendment to the law provided that a company cannot be put into insolvency if the default has occurred during that period of March 25th, 2020 to March 24th, 2021, which is quite, I would say quite stark, because even if the default continues, and we are talking about zombie companies, but if the default continues, it's likely to be a dead company, not a zombie company. And even in that case, the creditors do not have a choice to put that company into insolvency. So I'm slightly at a loss to understand why it was done that it can never be filed, but let's see how that evolves. In terms of what's happening since the temporary measures ended, as I said, the primary measure of not putting a company into insolvency ended in March. So we have now seen approximately 6 months. Just to put this into context, India has had an NPA problem even before COVID. Our banks were at 9 to 10% of NPLs even before COVID. And with COVID, there was a lot of support that came in. $60 billion is the last number count that was provided by the government. But at the same time, what we saw is our courts slowed down because of various judicial, and some in the audience might know how difficult India is in terms of judicial process, which became quite difficult even for insolvency, which led to sort of, I would say, a bit of a backup even before COVID. So what we have not seen is that a sudden flood of company coming into insolvency after the COVID measures ended. We are still, I would say, in sort of warming up zone for that. Neither have the NPLs and the companies which were defunct even pre-COVID have started starting to find a solution under insolvency, nor the companies whose business models were affected substantially and I would say permanently during COVID are yet finding an insolvency solution. The sectors, I would say, remain the same as what you mentioned, Christian, but I would add entertainment as well as travel to it, which have been affected quite significantly. And in fact, I would say travel is still not picking up in India, and all the other sort of industries, for example, real estate or auto, have started to pick up. But we are not seeing, it's been 6 months, we have not seen a tsunami of companies into insolvency. And however, it is my estimate that given where we are and given the sort of buildup of non-performing loans that we have, we will see more and more companies finding solutions through insolvency in the coming 6 months. And some of those will certainly be a COVID-affected bunch of cases. So that's, I would say, that's where we are in terms of India. Paulina, can I turn it over to you? Do you think the temporary measures have created the lifting of temporary measures have created sort of a welcome environment for defunct companies in Australia?
Yeah, thanks for that. So definitely there was the policy to try to keep Australian businesses operating during a period of sort of temporary illiquidity that was anticipated with the pandemic and associated restrictions, and in particular to try to keep companies from entering some form of external administration, which includes liquidation. So this was a policy that was expressly articulated and was behind the temporary measures that I was mentioning earlier. So in terms of trying to keep companies from entering external administration, we can see from the data that's been published by our regulator here, which is the Australian Securities and Investments Commission, that policy has been successful. Just to sort of put this more precisely, if we look at the financial year of 2018 to 2019, the number of companies that had some form of external administration, which, as I said, includes liquidation and also controller appointments, the total was 8,105. Then looking at the last financial year, so we can see a slight drop because sort of in March, we had the lockdowns commencing and so forth. And so part of that is caught in the figure. So we had in 2019 to 2020, 7,362. So almost 1,000 sort of drop. But then if we look at the very last financial year, so 2020 to 2021, we actually only had 4,235. So that's less than 60% of what the previous financial year's figure was. So definitely the policy of trying to keep companies in business operating and not entering external administration has been working. The question though, that's really on my mind and that's particularly relevant to what we're discussing now is, are all of those businesses that would have generally been expected to enter some sort of external administration that didn't end up going into external administration or appointing a controller, are all of them viable? And this is the potential problem, that if we're having policies that are actually supporting businesses that should not remain in the marketplace. The other thing is that in terms of the temporary support measures, so and particularly the winding back of the temporary safe harbor that directors had about insolvent trading, and also the winding back of those raised minimum amounts that your debt has to be before you serve the statutory demand and the period for responding to a statutory demand. So it was anticipated that as those things are wound back, that we were going to have some kind of a wave of insolvencies and a lot of external administrations and controller appointments. But that sort of prediction did not eventuate as yet. So I was looking even at in this financial year, so looking at July and August numbers, and still we haven't had a return to what Australia was seeing previously in terms of appointment numbers. And this is notwithstanding the fact that in Australia, we've also introduced permanent legal options for companies. So as of 1st January of this year, 2021, we've now got as an option for companies but only eligible companies, which are small companies, a simplified liquidation process. And we also have a new debt restructuring mechanism in place. And that's under Part 5.3b of our Corporations Act. And in addition to that, we actually have 2 new permanent safe harbor provisions. And these apply before and during restructuring. And when I say restructuring, I'm referring to this new restructuring regime that we have. So there's a lot of legal options that have commenced as of this year, and they're available, but notwithstanding their availability, we're still not seeing the number of external administrations go up to what it was previously. So the concern is about how dynamic is the marketplace. Are inefficient businesses exiting? And so on this point, I was recently reading the Reserve Bank of Australia's Financial Stability Review, the October edition that was recently published. And they talk about the fact that the financial support from government is actually keeping the insolvencies low, at a low level compared to what we normally see here. And it's providing a lot of liquidity. And it's also providing, according to the Reserve Bank of Australia, time for distressed businesses to either restructure or to wind down without insolvency. So it's possible theoretically that what's happening is that companies are exiting the marketplace that are inefficient and non-viable, but exiting it without insolvency. So without any need to have an external administration of any kind or appoint a controller. However, that's just one possibility. And I think it's a bit fanciful to think that every company that should be leaving is in fact leaving. The fact that we have so much less in terms of numbers of appointments is probably indicating that some businesses that should really be exiting, perhaps because of all the financial support and so forth. Perhaps management is thinking, oh, we can turn things around. And so the business is continuing. And the question is, once all the financial support is wound back, what will happen to them then? So will we see sort of a drastic rise in external administrations and appointments of controllers at that point? And so there could be, I mean, Australia's, I've seen research showing that Australia has always kind of had a bit of a problem with zombies, and I am concerned that that's on the rise. Notwithstanding the financial support, it could be that it's just keeping these companies going when really they don't have much of a future awaiting them. So that's Australia in a nutshell. I'll turn it over to Kathlene, because I think in the UK, they also have a permanent restructuring tool, right?
Right. So England's enacted a new permanent restructuring tool as of last year. It's beyond the scope to go into the details. But I think it will be a good landing for companies. I also understand, Christian, and Dhananjay, that there are new tools in both Germany and India. Unfortunately, we don't have time to go into that. I want to just wrap up quickly and move to the Q&A to see if anyone has any questions. And if not, we'll just go to our final words. Right. So so it looks like we are good to wrap. In England, I think we'll see the reckoning will come in waves. I think it'll be staggered based on really the financial support waning and loans coming into repayment. We're just starting to see some loans entering repayment, but a lot of these are 10 years out and pay as you grow. So so there could be a lot of room for these companies to eventually recover, but maybe continue to be zombies for a while. Christian, your thoughts, your last words?
I think we probably see, at least for Germany, that the zombification will become a problem, and it's not going to be solved quickly. We have a new scheme here as well, but I don't think it'll solve the problem. So ultimately, insolvency will take them off the market. The question is when and how, and what will be the trigger event or the trigger events for that. how do you look into the markets? I think our expectation is that we will see an increase from now on, probably in 2022. It's never going to be the big wave or the big tsunami, which we all maybe had expected at the beginning of the pandemic. But we will clearly see that these defunct business models need to exit a market, and maybe an increase of the interest rates or a similar mechanic will have a wider effect outside certain niche markets.
And DJ?
Just take a minute on India did introduce a new process for small businesses. It is not available to larger businesses. It's been rarely used so far. We have had only one company use it. So, frankly, I don't think it is going to be very useful. But overall, in the insolvency market, given the legacy that I spoke about and the NPL buildup that we already have, I do expect the number of insolvencies to rise. It will not be a tsunami, but it will be a wave that hopefully will be manageable for the government and the registry. Paulina, hand it over to you.
Yeah, it'll be interesting to see what happens with the new Part 5.3a. I mean, we have this mechanism available. It has already been used, but the uptake hasn't been particularly enthusiastic. So it'll be interesting to see what happens.
Well, thank you all for joining us, and happy Halloween. And welcome to the new III members and the new III NextGen.
Thank you all for a terrific panel. Appreciate all your efforts and your time.